Good afternoon, Ms. Allen-Yaman.
Good afternoon, Chief Justice.
Did I pronounce your surname correctly? Did I pronounce your surname correctly? I said Allen-Yaman. Are you sure? You must tell me if I'm not pronouncing it correctly. I don't like people not pronouncing my surname correctly, so I don't want to pronounce anyone's surname wrongly. Let me welcome you to this interview on behalf of all the commissioners. We appreciate that you have made yourself available for consideration for appointment as a judge in the Labour Court. I will ask you questions, and other commissioners will also ask you questions. Our questions will be aimed at establishing how your track record fits in with the selection criteria that we have adopted for the selection of judges. We might be robust when we put questions to you, but we don't intend to humiliate you or demean you in any way. It will simply be an attempt to satisfy ourselves whether you meet all the criteria. You understand?
I do, thank you.
Okay, thank you very much. Do you hold 2 degrees, BProc and LLB?
That's correct.
Both of them from the University of South Africa?
That's correct.
And did you get your BProc with distinction?
That's correct.
And that was in 2000, eh?
Yes, if I recall correctly, yes, 2000.
And then you got your LLB in 2001?
That's right.
And then you did articles, is that right?
That's right.
And that was from Feb 2001 to February 2003, is that all right?
Yes, that's right.
And you were admitted as an attorney in April 2003?
Yeah, I haven't looked at the date specifically, but whatever I put in there, that sounds right. It was shortly after I'd completed articles.
Oh, you know, I still remember the day I was admitted as an attorney. I can tell you the date.
Can you?
You don't remember? It was not a big deal.
I think it's just because so much time has passed since then. And
too many other things have happened.
Yeah.
Yes. And then you changed at some stage and you went to the bar, is that correct?
Yes, prior to that, obviously, I worked as a professional assistant as an attorney in a capacity at 2 different firms prior to going to the bar.
Did you practice as an attorney for about 5 years or so?
Let me see, so it was about 3 years at the first firm at which I worked, and then I went overseas. I qualified as a solicitor, although I didn't find any legal work over there. And then thereafter, I worked for another year as an attorney in another firm here in Johannesburg. And then, yes, did my pupillage thereafter.
So how long did you practice as an attorney then?
Yes, it would be about 4.5.
About
4.5 years, I think.
Okay, okay. And what made you change and decide to go to the bar?
A great deal of work that's conducted as an attorney involves a lot of administration work, not necessarily dedicated to the pure practice of law. It's client management to a great deal of one's time is spent on aspects which aren't specifically legally based, and I wished to focus exclusively on the practice of law.
Yes. And in your questionnaire at paginated page 11, you are required to outline your entire career in the law, giving an indication of your principal areas of legal interest and involvement.
Yes.
And you said, having completed my articles of clerkship in a general practice firm, I obtained employment in a firm in Durban Then your practice entailed both litigious and non-litigious work relating to employment issues. This type of work was undertaken by me when I relocated to Johannesburg. As an advocate, I elected to maintain my practice in the field of employment law and have since commenced practice regularly representing litigants in the various fora dedicated to the resolution of employment law disputes. That's what you gave.
Yes.
You may have intended to, but you didn't specify, for example, which courts you may have appeared in. Have you been appearing in the labor court? Have you been appearing in the labor appeal court? How often have you gone beyond the labor court? Labor appeal court appeared in the constitutional court, even if it's on labor matters. You didn't give that kind of background.
Sorry, I thought that it was covered under paragraph 6 on the following page where it deals with court practice.
Sorry?
I felt that it was covered under the following page at paragraph 6 where it deals with court practice.
Oh, okay. No, then I think you may be right. But tell me in terms of the courts where you have been appearing as an attorney and as an advocate.
Well, starting as an article clerk, I would go to the magistrates' court fairly often. That was in a general practice firm, so anyone familiar with being what's now a candidate attorney will be well aware of Section 65 inquiries, as well as all those other small interlocutory applications that can be done in the magistrates' court. So that's where I started. Then when I proceeded to working as a professional assistant with Farrell and Associates, that was a dedicated employment law firm. And at that firm, I would be able to go then to the CCMA, bargaining councils, and the Labour Court. I don't believe I attended the Labour Appeal Court at that, no. Travelling then up when I came to Johannesburg, that, if I recall correctly, the nature of the work, because it was an employer-based, employer-focused firm of attorneys, there was less CCMA work for me, so I did on occasion appear in the Labour Court there, but most often in that firm the philosophy generally was to brief counsel, so it was somewhat rarer at that stage. Then having moved to the bar, although my practice has been predominantly labour, which has entailed appearing at the CCMA, bargaining councils, internal disciplinary processes, the Labour Court and the Labour Appeal Court. I have also appeared in the smaller part of my practice, which entails civil litigation in the Magistrates' Court and the High Court from time to time. Yes,
but as an advocate, you have also appeared in the Labour Appeal Court, is that right?
That's correct, yes.
Yes, actually at page 14, you have got a list of reported cases in which you have appeared, is that right?
That's right. Correct page. So, Chief Justice, if I may, I was going to bring this up later in due course, just as something that's come to my attention on that page as I was going through it.
Yeah.
At the very bottom, I'm not sure how it's made it in there. It is a complete mystery to me. There is a case listed, Nongoma Local Municipality versus Biela and others. I had nothing to do with that matter. It is not one of mine. I've printed it out. I've looked at it. I wondered why its name was not familiar to me, and the reason is because I was not involved in that. I do sincerely apologize.
Yeah.
It was certainly not intentional. There's nothing particularly... It's very similar in principle to the Utugela one, so I don't... which I was in, but... if that could please be removed, and I apologize for having included it. It was an error.
Yes, yes. But those are the reported cases.
The others all are, yes.
That how many are there? You didn't mark them.
Beg your pardon, ma'am?
How many are they, the reported cases in which you have appeared?
I didn't actually count.
Yeah. That looks like around 15 or so, maybe 20, I'm not sure. Maybe about 20. Does that sound more or less right?
As long as you've minused the one that I said wasn't.
Yeah. Yeah, well, I'm saying about, not necessarily exactly.
Yeah, it looks about 15 to me.
Yes. So it looks like you started appearing, or starting having reported judgments in around 2015, is that right?
The earliest,
No, 2013?
I see a 2012 one.
2012.
There. The Lovemore Brothers one.
Soon after you started practicing as an advocate?
Yes.
Yes. And have you acted in the Labour Court?
I have, Chief Justice, for approximately, I think it's 48 weeks now in Durban.
48 weeks. That makes it how many months? In terms of acting stints, you have not been acting.
It's over.
In terms of a term, you have been coming for.
No, it's been a number of terms. The terms are listed there. From 2022, there was a month's period starting from.
Well, four terms would be a year. 4 terms.
Yeah, it's just a little short. I'm acting again now till the end of this term. So it was 1 month in the first term of 2022, another month in the third term of 2022, the whole of the fourth term, the first term of 2023, save for the first month because I had other commitments. Mm-hmm. And then that carried on through to the end of the second term, the whole of the third term, and now we're starting on the fourth term.
Yes.
So almost this year, almost continuously. Last year was slightly less, but
yes,
the total is 48.
How have you found acting in the Labour Court?
I enjoy myself.
You enjoy yourself?
I do.
Okay.
I find it thoroughly challenging, indeed.
Yes. Now, which matters that you would say when they are brought to the Labour Court before you know this matter must go to the High Court, matters that are employment related?
So, Chief Justice, if you could just, you mean specifically of ones I've dealt with or generally?
Generally. In other words, if I want you to give me a few matters, maybe 1 or 2 or 3, to say, no, but those, the Labour Court doesn't have jurisdiction in those employment-related matters.
Well, the starting point is 157, which gives Section 157, which gives the Labour Court and the High Court concurrent jurisdiction. Insofar as the things that the Labour Court cannot deal with would be those things that are exclusively required to be dealt with elsewhere in terms of the Act by other fora. Insofar as employment disputes which are not to be dealt with by the LRA,
or which could be dealt with, should go to the CCMA, but which should not be dealt with by the Labour Court.
But did you say, I thought, Chief Justice, I thought you said High Court. I
said High Court, I would like that, but I would also like to know which ones you would say, no, those must go to the CCMA or...
Okay, well, let me deal with the CCMA first. That's probably easier. So, insofar as the CCMA is concerned, it's any matter which the LRA specifies must be dealt with by way of arbitration proceedings. Mm-hmm. That would include anything under Section 191(5)(1)(a). Mm-hmm. Those are all your ordinary unfair dismissal disputes and unfair labour practice disputes. Mm-hmm. The only matters which are required to be dealt with by the Labour Court as far as dismissals are concerned would be operational requirements terminations on the larger scale, say for singular employees who have an election. If they wish to go to the CCMA, they may. Automatically unfair dismissals, and anything relating to a contract of employment arising out of Section 77(3) of the BCAA.
Where should that go?
That can go to the Labour Court.
Yeah, okay.
insofar as, then there's obviously matters of concurrent jurisdiction and circumstances where there is a constitutional violation.
Yeah.
I'm having a very hard time trying to think of a labour matter which ought to go to the High Court, because I have a general view that those types of things ought to just go to the Labour Court if they can.
Yeah, if there are, you say there would be few.
Few and far between, because something is either going to be a right arising out of the LRA or out of a contract.
Yeah.
Conceivably, sorry?
Then the Labour Court would have concurrent jurisdiction.
Under Section 70, well,
yes.
Concurrent jurisdiction under Section 157, or also concurrent jurisdiction with a multitude of other courts under Section 77(3).
Yes, yes.
And oftentimes, I believe what seems to happen is I've known it that individuals try to go and use the civil courts, the magistrates' courts or the high courts for claims arising out of their contracts of employment simply for payment of money. And then the difficulty they face there is that the magistrates in the High Court have this general view that it is not the right forum, and then they themselves find they don't have jurisdiction where they might otherwise have. Yes. So it's simply easier for them to come to the Labour Court if they can.
Yes, yes. Now,
if that has answered your question, I'm not sure.
Yes.
I still haven't found a High Court matter.
It might be difficult because the Labour Court has concurrent jurisdiction and exclusive jurisdiction, but the High Court has concurrent jurisdiction but no
exclusive jurisdiction.
Yes, yes.
Thank you.
Let's talk about reviews of arbitration awards from CCMA and bargaining councils. What are the grounds on which the LRA says they may be reviewed?
Okay, well, the starting point for an arbitration award would be a review under Section 145(1), which provides that an arbitration award, actually arbitration proceedings, may be reviewed on the basis of any defect. Section 145(2) proceeds to define defect to include misconduct, gross irregularity, or the accession of powers, unless an award has been, can also be reviewed where an award is improperly obtained. Those obviously reflect fairly narrow grounds of review, and the courts were required to consider whether those very simply put grounds could be all that there was to it. And as our case law has evolved, I would say that there are three cases which evince the evolution of the test for grounds for review. The starting point would be Sedumo, the details of which are reflected in a 200-page judgment. So my brief summary of the conclusion reached in that is that ultimately the ultimate test when one is assessing whether or not there's been a gross irregularity is whether or not the award is one which could have been arrived at by a reasonable decision maker. In amplification of that, to the extent that there may have been any ambiguity, the Supreme Court of Appeal subsequently in 2013 considered the matter in a decision that Hadholt, I'm sorry, I can't remember the rest, I only know it as Hadholt, I can't remember the rest of the citation. The question was that when will that be reviewable, and per the court was that for a defect to constitute a gross irregularity, the Commissioner must either have misconceived the nature of the inquiry or have arrived at an unreasonable result. And in the event of one or either of those scenarios would result in effect, a result that no reasonable arbitrator could have arrived at. And then finally, the LAC considered the issue in Goldfields.
Well, no, I didn't want you to go into details. I wanted you to simply say these are the grounds.
Okay. Well, those grounds would be reflected on the three, the gross irregularity.
Yes, but you have said something that I want to follow up. You said, if I heard you correctly, that to determine whether there's been a gross irregularity, the question would be whether a reasonable person, I'm not sure whether you said would or could have arrived at the decision. Did you say that?
Could, I think is the test.
Could, you said, okay.
I might have said would, but
yes.
I think it to me amounts to the same thing.
Yes, but are you not talking about two separate grounds of review there? Isn't gross irregularity one of the grounds of review under Section 145 of the LRA?
No, that is precisely it. If I've misunderstood the Sudumo judgment, it was to establish what gross irregularity was, because I understood the reasoning to be that in the performance of a commissioner's duties, the commissioner is required to conduct him or herself in a certain manner. In so doing, that commissioner needs to have consideration to the evidence before him or her, to consider, to afford parties a fair opportunity to present their evidence, to have identified the actual issue. By having conducted a fair hearing, it then gives rise to a result. The question of reasonableness, as I understand it, is read within the gross irregularity, because in the event that a commissioner commits one of those types of errors, wrong word, commits that type of conduct by not having conceived the nature of the inquiry, by not having conceived the evidence, etc., that in itself constitutes a gross irregularity. So it's not a new ground of review, as I understand it. It is just to simply understand the extent to which a gross irregularity may be found present within an arbitration award, thereby leading to an unreasonable result.
Yes, you might wish just to later on go and have a look properly what Sudumo said. Part of what you're saying, yes, but I think you may be mixing it up with other things. But tell me, what are the requirements for an interim, for the granting of an interim interdict?
An interim interdict will be granted in circumstances where the applicant seeking the interim interdict has established a prima facie right, although possibly open to some doubt, will potentially suffer irreparable harm if the interim interdict is not granted. The balance of convenience, is in favor of granting it, and there is no alternative remedy available to the applicant.
What are the requirements for a final interdict?
All the same, no, they're not all the same, similar. No need for balance of convenience, a clear right, no alternative remedy, and irreparable harm.
And what's the difference between a secondary strike and a sympathy strike?
I'm not 100% that I'm going to be able to answer. Secondary strike, as I understand, is one that is in concert with a main strike in the same industry in which the secondary strikers participate in the main strike for the purposes of obtaining or achieving the demand, whereas a sympathy strike might be taken up by individuals who are not necessarily within the industry. I am subject to correction on that.
Yes. And you are going to be, if you are appointed, conducting trials in the labor court. When can you draw an inference? What are the requirements for the drawing of an inference in civil matters? Are you familiar with that?
No, I'm afraid I don't know what the test is there.
You don't know what it is? Okay. I'm going to give the opportunity to the Judge President of the Labour Court to put questions to you.
Thank you.
Judge President.
Thank you, Chief Justice. Good afternoon.
Good afternoon, Judge.
Is it correct that you are seeking an appointment in Durban, seat of the Labour Court? Is that correct?
That is correct, Judge President.
I see you've really provided us with lots of paper. Why was the need to give us all your judgments, Renia?
I do apologize. I see that the Law Society took a little bit issue with my wasting the trees. The reason for that was this, is that the work of the Labour Court covers a multitude of different aspects. To select only one or two different things that may conceivably be perceived to have been important wouldn't necessarily give the fullest indication of my understanding of the area of law. And to be fair, I did provide an index which described each of the cases, so I was hoping that rather than forcing everybody to read all of them, that they would simply choose the ones they wish to. So I do apologize if I'd done that.
I see that the person who nominated you, in fact, said that the experience is exclusively for employees. But then as I kept on reading your CV, I saw that you had worked for ENS. I thought that you worked for employees when you worked there.
No, I would imagine that was, sorry, I didn't actually see that, but I would imagine that he intended that in my capacity as an advocate.
Now, you know, the last few years been very fashionable for employers to raise the issue of derivative misconduct. Can you tell us about that?
Sorry, I didn't catch the first part of the question.
Derivative misconduct.
Yes.
If you can explain what it means and is it still applies?
Oh, I see. It was a principle which was established or which was applied for some time, in terms of which where the misconduct of employees in the perpetuation of a potentially violent strike would be attributed to others by virtue of a derived complicity. So in circumstances where they were deemed to have, effectively deemed to have participated, even if they'd been in the absence of any evidence that they had in fact done so. The notion of that such a concept of derivative misconduct could exist was came to an end with the decision, and I think it's Dunlop mixing, I think is the case, where the Constitutional Court said no, that is not an appropriate principle.
Okay.
So where one wants to establish proof of misconduct in the course of the strike, you need to be able to identify who did what when.
Do you belong to AFT?
I actually don't know.
No. Because I see you one of the only candidates that I know of who has been supported by the AFT for the position.
Yeah, it's not that it's simply it's not for any active or inactive choices on my part. I mean, the principles are what they are and what I believe in, but it's just simply a question of allocating precious time and resources to what one can and cannot do. So whatever I have done for the bar, I've done for everybody, not necessarily under any particular banner.
That helped me then. They say in paragraph 27, Advocate Allen-Yaman actively contributes to transformation at the KZN bar, particularly skills transfers. Help me with that. What do they mean? Yeah.
Well, no, it's AFT and the GC and the bar in Natal don't run sort of separate programs or separate anything from one another. So what I did was in the course of last year, I commenced preparing and then did at the beginning of the year, was presented a course for juniors at the bar, because it has always been my view that the practice of labour and the study of labour, particularly at the profession of advocates, is underrated and underappreciated. So anybody who has done pupillage or has done those exams will know that there are no examinations at the end of the pupillage year on labour. And with that in mind, I was aware of the fact that there are very many juniors who come to the bar who are completely unfamiliar with any labour or have had no labour practice or are unfamiliar with the principles. So what I did was, in my own mind, identified what I thought might be the things or the briefs that those juniors might receive in their first few years of practice, and with that in mind, what principles of labour law might be different or unique to labour that they would be unaware of. So I did a 3-day course where I presented the pupils, not the pupils, the junior advocates, with material which would, I felt, provide them with a solid basis on day one on disciplinary inquiries, how to run them, what to expect, what to deal with, and then potentially dismissals, what they might find at the CCMA or Bargaining Council, what the onuses are, all the intricacies of dealing with that. The second day I dealt with just general labor court practice, where there are different and unique applications. And then the third day I dealt with reviews. And it was a full 3-day course which was run in January. And then in July, it was I represented that for any juniors who hadn't been able to attend in January. And we were in fact fortunate enough, Judge Witcher from Durban, in fact, she accepted my invitation to come and speak to them on evidence, which she did. And one of my colleagues at the bar, Mr. Paul Schumann, who's also very familiar with labour, he came and spoke to them regarding strikes. So by the end of all of that, the juniors of the bar have a little, I hope, better understanding of where to start. And so that, I believe, is where the comment comes from.
Finally, I keep a record of all outstanding judgments and so on. When I looked at your application, I saw a number of outstanding judgments, but as far as I know, you don't owe any judgments for over 2 months, do you?
No, not now. Judge President, the ones that were listed there had all arisen in the course of the second term. As you would be aware, the Durban court is served by 2 judges. It serves the province with the second highest GDP in South Africa. It is not busy. The 2 judges in that court are required to alternate between trial court and motion court. Motion court starts at 10 in the morning and sometimes doesn't finish at 4. You can roll matters over to the next day. At the end of the day, during the course of term, there is very little time to write judgments unless one's trial collapses and one doesn't then go and help one's colleague with her motion court role. So all I can say is that, yes, at this point in time, I have no judgments which are outstanding for longer than 3 months. Those ones that were listed there at the time were not longer. There is one on the list, though, the very first one, and it's the one that the GCB mentioned from April, which was of concern. I must just draw that to your attention. Pursuant to having reserved the judgment, the applicant party took a further step in the matter by, they took a further step. That necessitated that I issue a directive to the parties as to whether they wish to argue, because the step was taken affected the argument. They both then delivered further submissions. So once that was done, it was it's been re-enrolled. I believe Mr. Vilakazi will enroll us next term. I'd asked him to do that. So there's the reason why one is not handed down is in fact because it needs to be argued again on the new merits. Judge President, at the end of the day, I have acted for 48 weeks over a period of 80 weeks. I have handed down 72 judgments in that time. The volume of paper that you have before you indicates that these are not 1 or 2 pages. These are reviews. These are substantive applications. So on average, 1 a week. If there have been times where they have been delayed beyond 3 months, it's certainly not because of any...
But there haven't been, there have been 1 or 2.
There might have been 1 or 2, but certainly not because of any indifference on my part to the requirement that labour be dealt with expeditiously.
Thank you. Nothing more, Chief Justice.
Thank you, Judge President.
Thank you, JP. Minister, you are covered. Commissioner Marumwahai.
Thank you very much, CJ. Good afternoon, Judge.
Good afternoon.
Yes. I read your judgment, Hatting and others versus Design Group. I'm not sure if you remember it.
I think it was one of the very first ones. It was in the COVID time, wasn't it?
No, in fairness to you, I'm not going to take you through it. There's just a question that came out of it that I want you to address, just a general substantive question. We all know that employers take sometimes they just change unilaterally the terms and conditions of employment at times. I just want to understand, what is the common law position with respect to unilateral change of terms and conditions of employment? And do employees under those circumstances have any remedy? If yes, what would then be the remedy for employees under those circumstances? Thank you.
Specifically the common law.
Well, there will be a position under common law that we all know, and perhaps maybe that position may have been changed by some of the statutes that came through, but I'm not debating that. Okay. I just want to know what is the original common law position, because it's still applicable. And if employers go ahead and they just unilaterally change terms and conditions, is there any remedy for employees? You deal with that in your judgment, so I just wanted to be fair to you.
I think it was ancillary in the judgment because the arguments of those employees had been that there'd been a change in terms and conditions of their employment, but I found, if I recall correctly, I found they hadn't, because they'd always been required to travel and would have always inherently been required to comply with whatever vaccine requirements other countries had required. Be that as it may, my understanding is that as a matter of common law, once one enters into a contract, one is bound by that contract, and there is no scope for any unilateral change to terms and conditions of employment. The situation that prevails insofar as unilateral changes to terms and conditions of employment are implemented in a broader, insofar as more than one employee is concerned, the employees as a collective can then use the remedies in the LRA to interdict for at least 30 days the implementation of the change and thereafter strike. Individual employees cannot strike and would have to use some type of civil remedy for specific performance.
Thank you very much, Judge. Thank you very much, TJ.
Thank you very much. Commissioner Paul-Swallow-Dolly.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon, I think.
Yes.
Not Judge yet. Everybody's calling me Judge. You've had a long week with many judges.
Well, we've had many judges.
I know.
I guess it's because we've had many judges throughout. Good afternoon, Advocate.
Good afternoon.
Yes, you know, Section 198 of the Labor Relations Act is designed to protect vulnerable employees from labor brokers and those on fixed-term contracts. In your experience, do you think it's working practically? In your experience, looking in particular at sections 198B and D, is it working? Is it effective?
Commissioner, I'm not able presently to tell you which one is A, B, C, or D. I can tell you which are working and which aren't. Yes. The automatic permanency of repeated fixed-term contracts of employment is working. There is no doubt that the effect of, or what the historical employee unskilled, usually workers, for extended periods over repeated 1 month fixed-term contracts seems to be a thing of the past. I think that if people are trying doing that, the employees know the remedy and are able to get that fixed. Insofar as the actual notion of labor broking is concerned, the difficulties inherent with labor broking will remain with employees for so long as it is permitted, but it has not yet reached a point where I think it can be done away with, because there is always going to be a need for labor broking. And on a case-by-case basis, I mean, it's very difficult in abstract to say whether one scenario is fair. you know, whether it is whether it's operating fairly or otherwise, because each case will be dealt with on the basis of the employer's specific needs at the time, whether they are using labor brokers to avoid consequences of permanent employment, or whether they are doing it for a genuine operational need, has to be determined on each basis. I don't know if that answers your question sufficiently, Commissioner.
Yes, to a certain extent. May I just follow that up?
Sure.
But really what I need to know is that in your experience, when the issues come before you, are you applying those provisions to adequately protect the employees?
To be honest, in none of the judgments that I have dealt with so far have I had to deal with any of those particular provisions. None of them have come up in any matter before me as of yet. I have had discussions with my colleagues concerning those matters. There are difficulties with the interplay, as I understand it, in those particular provisions, particularly in light, I think there's a judgment which has indicated, but I think it's gone to the LAC, and I'm not sure whether there's been a decision, as to whether or not the termination of an employee's employment, post-fact whatever the event, so in other words, if an employee has acquired permanency of employment and has claimed a right under that but not yet enforced it, whether that can now be negated by virtue of the termination subsequently of the employment. I think there ought to be an LAC decision. Has it been handed down yet? Judge President saying it's not yet handed down. But I was involved in a debate on that, and there are certainly, it's the way any new provision gets dealt with in the LRA is that it needs to be tested. And until it's been, those ones I don't think have been sufficiently fully tested, and hopefully when the LAC hands down its decision, there will be some clarity there. But with all of these, there is always an attempt to find a way around things. But it's a step in the right direction, I would say, at least. And I'm sure that from what I've understood of it, it certainly does provide at least a better remedy than none.
Thank you, Chief Justice. Yes, indeed. Really, the manner in which employers seek to circumvent that provision is by just terminating the employment, and then you cannot invoke Section 98.
I disagree that it can't be done.
Thank you very much.
Thank you, Chief Justice.
Thank you, Commissioner.
Commissioner Dodovu.
Thank you, CJ. Good afternoon.
Good afternoon.
Advocate. My question is only one, and it's premised on your judgments around unfair dismissals. As you are aware, dismissals can generally be effected on 3 grounds. That is because of misconduct, operational requirements, and incapacity performance. Now, my question is, can an employer dismiss an employee based on these grounds simultaneously? Is it possible?
Depend on what was happening in the business at any one time, I would imagine. I mean, notionally, there would be an employee that misconducted himself in the course of an operational requirements consultation process, which was imminently to lead to the termination of his or her employment on a specific date, and at the same time found himself at the end of a poor performance management inquiry, thereby rendering his dismissal, saying his or her dismissal on a specific date, to have been for any one of those 3 things in the alternative. But I've never seen an employer choose to do it on all 3 bases. They usually pick only one.
I'm asking this because each case has got its own processes prescribed by the LRA. And I remember as a sub-steward, I argued that you can't do it in 3 instances at the same time, and I was successful. Now I wanted to test you because if you
I'd
are
have to
appointed, you'll be a
understand. I mean-
judge, and you'll be confronted by such a situation where an employee is dismissed both on retrenchment, non-performance, and misconduct at the same time.
As my answer indicated, that the probabilities of those three events happening so as to meet, like the Titanic and the iceberg, on one day, with all three, it seems highly improbable. Not saying it's impossible, but just the chances of that are fairly remote, it would seem to me. And I mean, you only need to fairly dismiss somebody for one fair reason. You don't need to have three.
Thank you very much, CJ.
Thank you.
Thank you, Commissioner Singh. And on my list, you, subject to the commissioners on the virtual platform, you would be the last one.
No, thank you very much, Chief Justice, and good afternoon, Advocate. I'm here.
Oh, there you are. Thank you.
Advocate, I note that you've presided over the Nando's-Scottville versus CCMA, and this was a very interesting case that highlighted that despite our stringent labor legislation in the country, you find that employers often with deep pockets and a string of lawyers, often take advantage of the employees, particularly after a judgment has been given. Now, what do you think both employers and employees can do post a judgment like the one that was given in this case?
But that one was a little bit different because that one, in fact, had a happy ending. It didn't have the scenario of, oh, well, we've lost, so now we're going to drag this employee all the way to the Constitutional Court on principle. They published, an article was published whereby they said that they accepted the judgments and were welcoming him back to his job and were making the necessary arrangements. Yeah, so that particular one didn't have the evildoer employer with deep pockets, I'm afraid.
Yeah, could that not have been an exception rather than the general rule? And what would you suggest needs to happen post the judgment?
Well, every litigant has a right to the fullest processes of the law, and as things currently stand, that includes the right of, well, the right to at least apply for leave to appeal. What could be done to stop that? Potentially cost orders against people, but that can only be done where one is in the labour court very certain that they are acting frivolously or vexatiously. So.
Yeah, I also note that you were admitted as a solicitor in England and Wales.
It was purely academic.
Academic. You didn't practice there at all.
I tried. Nobody wanted to give me a job.
Thank you. Thank you, Chief Justice.
Thank you, Commissioner Singh. Commissioners on the virtual platform, I didn't see any indication. I take it there are no questions from that side. Yes, there are no
questions, CJ.
Thank you.
Where am I?
We've come to the end of this interview. Thank you very much. You are now excused.
Thank you very much, Chief Justice. Okay. Thank you very much, Commissioners. So before may I just hand something to Judge President Wagley? I know I've given you a lot of paper. Of all the cases that I presented, they were all applications. Fortuitously, between the time of the application and now, I did have an opportunity to write a judgment in a trial matter, which I know is assessed differently, as Lordship asked. And this is in relation to an automatically unfair
I don't think you should add to what you have already given us.
I just thought I would bring it just in case. All right. Thank you very much.